Hello, and welcome to the appeals page. Before we continue, there is a disclaimer. The information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you to consult with an attorney. Now I will be discussing the legal process of an appeal, the standard of review, and the explanation of how the forms work. The overview of what an appeal is that an appeal is a request for a higher court to review a lower court's decision. The party that lost the trial case or is unhappy with some part of the decision that has been made by the lower court is able to make the appeal and is called the appellant. And the other side is the respondent. The respondent may also file an appeal and make it a cross appeal. The higher court does not re-decide the facts of the case or enter new evidence because it is not a trial, but it does determine whether the trial court properly applied the law, meaning correctly. To win, there must be a legal mistake that the trial court made. This may go to the Court of Appeals or the Supreme Court of California or the U.S. Supreme Court. In order to file an appeal, you will need to prepare a notice of appeal, make at least 2 copies of the notice, serve your notice of appeal on the other side, file the notice with a proof of service with the court clerk. No later than 10 days after filing, you must designate the record. Now I will discuss the possible outcomes of an appeal. The appeal requests that the appellate court do one of the following: that it reverse the judgment, to enter a judgment opposite to the one that was entered, or to modify the judgment, to change a particular part about the judgment to correct it, or to affirm the judgment, which is to agree with the original judgment, and to remand. This is to return the case back to the lower court to do some action. Now I will talk about the standard of review. The standard of review is the extent to which the appellate court will substitute its own legal judgment for that of the trial courts. There are different kinds of review for different kinds of trial court decisions, such as the abuse of discretion standard, the substantial evidence standard, de novo standard, and the independent judgment. The abuse of discretion standard is an error justifying the appellate court's action, which is when the trial court denies admission of evidence without good reason. The substantial evidence standard is the most common standard of review, which is when evidence supports the judgment. For the de novo standard, the appellate court looks at the beginning of the issue as if the trial never made the judgment, exercising its independent judgment. But this is not a new trial, as the court is not looking at new evidence. Now here is the explanation of forms and process. First is preparing the notice. The notice of appeal must be filed before the deadline for the type of case you may have with the correct form, such as limited or unlimited civil case. Making at least 2 copies of the notice, one for yourself and one for the opposing party, and the originals for the court. Then serving the notice. The respondent is then served with a copy of the notice of appeal by person or by mail with a proof of service. The respondent gets a copy because the original goes to the court. Then filing the notice with proof of service. The original notice of appeal will be filed with a proof of service, and the clerk will return a copy stamped with the word filed. There's a filing fee, but if you cannot afford a filing fee, you can ask the clerk to waive it with a fee waiver. Lastly, after filing, no later than 10 days after you file the notice of appeal, the Superior Court must be notified what documents and oral proceedings should be included in the record. What will be sent to the Court of Appeals, which is called designating the record. Payment is required for the record being sent and the copy for your record. Thank you for visiting this page, and I hope this information has helped.